I mean, I'm sorry. I don't know what to tell you, but I'm always at a loss as to why some people find it convenient or necessary or acceptable to just ignore court dates. And now, and I got to tell you, if this was improper, anything unfair about this, I would feel bad. But I'm not a mind reader. I can't read people's minds that aren't in the building or aren't on Zoom now at this point about whether the debt is fair or unfair. This has been 9 years.
There's no data or document.
Payments on this account since you were in here.
Yes, sir. They arrived at the store one day and she did give me $1,500.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
All right. So you sued. I initially gave you a judgment in the amount of $6,361.60. She's made $1,500 worth of payments since then.
One time, yes, correct, sir.
So the principal sum then, instead of being $62,1660, should be, correct me if I'm wrong, $47,1660, correct?
That's correct, Your Honor.
And then you have court costs of $75 and $70 in terms of filing and service fee. And then you have a total judgment therefore should be $48,5660, correct?
Oh, I didn't pay it, so I'm sorry.
Yeah, that's it. So I'm going to go ahead and enter a default judgment. I hope this is the last I'm going to go through this. So judgment is entered, $4,856.60. You can go down the hall and they will give you a copy of the judgment. Okay? Have a good day. Thank you. Capital One versus Melissa A. Koski, 2600108.
Good morning.
morning.
Jeff Werber, P67124 on behalf of the plaintiff.
Good morning, Mr. Werber. Ms. Koski, your name?
Hi, Your Honor. This is Melissa Koski.
All right. Did you talk to her at all, Mr. Werber, today?
We did, and we have resolved the matter, Your Honor. We'd like to place our resolution on the record.
Go ahead.
Thank you, Your Honor. The parties have agreed to enter into a consent judgment with installment payments. The total amount of the judgment, which includes the court costs, is $2,057.45. The defendant is going to make monthly installment payments of $50 starting on or before May 15th, 2026, and on or before the 15th of each month thereafter. I did provide her with instructions on how to make payments directly to my office. The defendant is willing to give me consent to sign her name to that consent judgment and get that filed with the court.
Thank you. Do you understand everything Mr. Werber just said, Ms. Koski?
I do.
He tells me that you are agreeing to a consent judgment in favor of the plaintiff against yourself. Total judgment amount, $2,057.45. If you, in the installment payment provision will provide that you have to pay $50 per month beginning May the 15th of 26 and the 15th of every month thereafter until paid in full. If you miss a payment, there's going to be language in that judgment which would then permit them to set aside the installment payment order and proceed with garnishment of your wages. They cannot garnish your wages so long as you make these payments as agreed upon. They could, if they wanted to, garnish tax returns. Do you understand? And garnish bank accounts. Do you understand that?
I understand, Your Honor.
Do you agree to all those terms?
I do.
Does Mr. Werber have your permission to sign your name to that proposed judgment?
Yes, Your Honor.
Okay, you're all set. Thank you, Mr. Werber. Any questions, ma'am?
I'm okay. Thank you.
Good luck. Thanks a lot.
Thanks, Your Honor.
Thank you. All right, Absolute Resolutions versus Tiffany Holly, 2600114. Good morning, Mr. Burke. Your appearance?
Good morning, Your Honor. Hal Burke, P69068, attorney for Absolute in this case. And I'm happy to say the case is paid in full. Ms. Holly and I had a productive conversation in the breakout room.
Ms. Holly, your name, ma'am?
Yes, Your Honor. Tiffany Holly.
All right, so we adjourned this on February 24th because I was told that you were going to pay this in full by the end of March. Are you going to submit a stip in order to dismiss with prejudice?
Absolutely, Your Honor. She made her last payment on I'm told by her and by Absolute on March 31st. I'm surprised it hasn't been filed, but it will be today.
Okay, so ma'am, and just, you understand what's happening. You paid this, he's going to dismiss the case with prejudice. He has to have permission to sign your name or else he has to send it to you. Does he have your permission to sign your name to the proposed stipulation and proposed order dismissing the case with prejudice?
Yes, Your Honor.
Okay, so I'll wait for that. I'll ask you to get that to me in the next couple of days. Mr. Burke, anything else?
Nothing further. Thank you, Your Honor.
Have a great day. Ms. Holly, good luck. Thank you.
Thank you, sir.
All right, what else?
It's 5 to 9, so.
Why don't you give me the 9 o'clocks and if somebody's here, I'll call them.
Judge, I don't have any matching parties yet.
Good morning. How are you? Good. All right.
So the judgment?
I gave it to you. So we don't have Speckled Frog Learning Center versus Vanderpool here.
I have Capital One and Herring, Herring, Devon Herring. It should be probably the last one on your stack there.
Capital One versus Devon Herring, 2600483. Good morning, Mr. Saloom.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Mr. Herring, you have to start your video, unmute and state your name, please. Or Ms. Herring, I'm sorry.
Hi, my name is Devon Herring.
Good morning.
Good morning.
So we adjourned this 2 weeks on April the 7th, or
Yes.
April 7th, I should say. That was back on March 24th.
Mhm.
Have you had any further discussions with her?
Your Honor, I don't know if she's contacted our office. I didn't notice that there were any discussions when I looked at the notes.
All right.
I could be wrong. I don't know if Ms. Herring can elaborate.
So I actually found out within this last year I was involuntarily hospitalized and found out that I have bipolar disorder 1. So I'm waiting on my Social Security disability, and I was manic when I spent that money as well. So that's what I'm waiting on now, is to see if the state of Michigan is going to consider me disabled or not, because that's what's preventing me from working.
Okay. Here's what we can do, ma'am. You file a document, an answer to complaint, where you acknowledge that the debt referenced in the complaint relates to your account. The amount that they're claiming here is $3,708.08 plus costs and judgment interest. What you can do, and I see you're saying you have no money to pay the debt, but what you can do is you can agree to a consent judgment. If you want to, I could put you and Mr. Saloom in a breakout room. And then I can swear you to an oath, and I can conduct a creditor's exam right now and make a determination as to how much you can afford to pay. Does that sound reasonable to you?
Yes.
So do you want to go into a breakout room with her, Mr. Saloom, and try to work out a payment arrangement and explain the consent judgment terms, and we can go from there? And then if you don't resolve the issue as to how much, what the installment payment provision should read like, I'll be glad to go ahead and decide that.
Sounds good, Your Honor. Thank you.
Okay, so we're going to put you two in a breakout room. Thank you both.
Yep, thank
Sure.
you.
Do I have Rebecca Sislow here by chance, Jennifer?
They're in a breakout room, Judge.
So the lawyer for Midland and
Yes.
Okay.
Yes.
What about One Main versus Hardacre?
She's in the courtroom.
Okay, is One Main Financial Group here? Somebody for
I am
them?
bringing them in right now.
Okay, ma'am, you can come right up here. And if you'd like, I see you're on Walker there. You can go ahead and have a seat right at the table or wherever you'd like, okay? So this is One Main Financial Group versus Kimberly Hardacre. And this is file number 2503497. Good morning, Mr. McNally. Your appearance?
Christopher McNeely, P45664, on behalf of the plaintiff.
Ma'am, your name? You don't have to stand. If you want to sit, if that will make you more comfortable, I have no issue with that. So just take your time. How much is the amount of this debt, Mr. McNeely?
$3,437.55.
Do you agree that you owe that amount?
Not that amount, I do feel that
All right.
I'm paying payments, and I try to make payments arrangements with that.
Well, I can do that for you. Okay,
I have like a social still.
I understand.
So.
They can't garnish those as long as you keep them separate. Yes, slow down. Mr. McNeely, I hate to have to send her to a room where she can Zoom with you. She's got a medical issue ongoing here. Do you want to tell me what give me the whole breakdown as to how much is owed here, if you would?
So the damages are $3,437.55. Court costs are $77.25 for the filing fee. And I better write this down as well, Judge. Sorry.
It's okay.
$20 for a alternate service fee. There's some other fees for certified mail and whatnot that I'm not going to put in there. The process server fee for posting it was $44.72. My client does charge a $75 statutory attorney fee. However, my client has stopped interest from accruing on the account as soon as they sent it to my office.
All right, so you have all those figures together. You got 20 plus 75 is 95, plus 44 is 139.72, plus 77.25 should be 213.97. And I want you to stop and correct me if you think I'm wrong. So your total here should be $36.51.
I got $36.54 and 52 cents.
Okay, ma'am, do you agree that you owe that amount?
He said he served me, he never served, I got something, you know.
Because they filed a motion for alternate service, but they had the process server go out a few times before that. Then they had to submit the motion. So you were properly served. They are entitled to that.
Oh, no.
Okay, so do you agree that you owe that amount, that being said?
Yeah, I don't know that far, you know, the original loan was 3,000, I paid.
Okay, just keep your voice up for me.
I paid, the original loan was 3,000, I paid 17.
Okay, it doesn't matter.
I
The interest was accruing.
got you, understand.
Do you have any reason to dispute that you owe the listen to my question. Any reason to dispute that you owe the $3,654.52?
No,
Do you wish to enter into a consent judgment with Mr. McNeely along those lines? At which point we can conduct a hearing with regard to installment payments right now if you can't agree. Do you understand that?
yes,
So do you wish to enter into a consent judgment with his office? And does he have your permission to sign your name to a proposed consent judgment that will be submitted to the court indicating that you owe in a judgment $3,654.52?
yes.
Okay. Now, I'm gonna ask you to raise your right hand. You can stay seated there. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God? So I'm gonna ask you to prepare a separate consent judgment and then an installment payment order, Mr. McNeely. Ma'am, what sources of income do you have? Do you have any stocks, bonds? Nothing else, just Social Security disability. Okay.
I received that's 1993.
Okay. How much do you receive per month?
I received 1788.
Do you have any questions for Mr. McNeely?
Not really, Judge. Unfortunately, my application says that she had income of $6,100 a month. So,
Say that again?
My application for the loan originally says she had income of $6,100 a month. So it's crazy that, because they don't tend to lend money on just,
When did she make her application?
when was this originally? 2024.
Pardon?
2024, June of
Did you-
2024.
Did you have $6,100? But let's just listen to my question. Listen to my question. Did you have income $6,100 a month back in 2024?
It was joint.
Okay. Are you married?
No,
Well, who was the joint income with?
it was a friend, but they were was screwed.
I'm sorry?
It was a friend, but they did not come through with what they were supposed to do. They were gonna help.
How much are you asking for, Mr. McNeely?
Would normally be $100 a month. Interest has stopped.
Yeah, I understand. Here's what I'm gonna order, ma'am. You get your check on what, the 6th or 7th?
Third,
The 3rd. All right. $60 per month, starting May the 10th and the 10th of every month thereafter until paid in full. 60 per month.
okay.
And this order is subject to review. This order is subject to review on motion of either party. This order is subject to review on motion of either party. Just stop. I'll explain it in 1 minute. On or after November 1 of 26. So if you think you're paying too much, you can file a motion. If he thinks you're not paying enough, if you've got other income by them in particular, then he'll have the right, or his office will have the right to file a motion to set aside the installment payment order and increase the payments. Okay? Do you understand everything here? Yes.
Yes,
Okay. All right, Mr. McNeely, anything else?
What was the date, Judge, that it would be a review date? And it's only if one of us,
On or after November 1 of 26.
and it's
So
only
that-
if one of us files a motion.
Correct.
Very
On
good.
motion of either party, on or after November 1 of 26.
I will submit the consent judgment with signatures for both of us, signing for both of us, and a installment payment order that the court has ordered. So I'll just submit that without signatures at all.
Thank you very much. Ma'am, have a great day. We'll send you the orders, okay? Is your consent judgment going to tell her how to pay it? You're going to insert that in there?
You know what? Does she have email? Otherwise, we can send it by mail as well.
Sorry?
Email or
I heard you. I didn't hear her.
okay.
Give him your email address.
it's KIM
KIM
HARD
HARD
AC
ACRE
RE 37
37
gmail.com.
at gmail.com. Okay?
All right. Thank you very much, Judge. We'll send it
Have a
out.
great day. Thank you.
Too.
Capital One versus Devon Herring, 2600483. Mr. Salome, your name again, sir.
Yes, Your Honor. Defendant agrees to a consent judgment in the amount of the damage amount is $3,708.08. We have $115.35 court cost, which is the filing fee of $75, service fee $40.35. Total judgment amount of $3,823.43. We're kind of submitting that. I guess we will submit that without payment term. She's indicating she's not working and is unable to make any kind of a payment. I know the court indicated it may want to do a creditor's exam. I have no, whatever the court wants to do, whether without payment terms or.
Principal sum is $3,708. Did you say 80?
No, 8 cents, Your Honor.
Okay.
$3,708.08.
Ma'am, Ms. Herring, do you agree to those, that amount, 382343?
Yes.
And do you understand that he is going to sign your name with your permission to that proposed consent judgment.
Yes.
Any problem with that?
No.
All right, so I can do one of two things. I can just leave this like it is, in which case, if you gained employment tomorrow, they could garnish wages. They still can garnish bank accounts if you commingle funds, so you have to be careful with that, and they could garnish tax returns. So
Okay.
I can go ahead and conduct this if you want me to and have a creditor's exam, or you can let this lie and understand that as long as you deposit your Social Security, assuming you receive that, disability into a separate fund with no other income going into it, that they cannot garnish that. Do you understand that?
Yes.
What do you want me to do?
I'm sorry, can you repeat it one more time?
Yeah, if you gain employment, they could garnish your wages. If you don't gain employment, they cannot garnish your wages.
Okay.
Okay, because obviously you don't have employment then. But if you gained employment, they could garnish wages if we don't have an installment payment order in effect. It doesn't sound like you think you can work, so I'm only telling you I'll do it either way you want. If you want me to do an installment payment order, I will. If you don't, I won't. And as long as you understand that if you don't commingle any Social Security funds with other income or other amounts in your bank account, that they cannot garnish those. I mean, they could, but you could file an objection and it's going to be deemed valid.
Okay. Yes, I would
So-
like to do that.
So you want me to just have him go ahead and prepare the consent judgment, sign your name and send it over, and we won't have an installment payment order?
Right. Yes.
Okay. All right. So that's
Thank
what we'll do. Mr. Saloom, you can send that over. Anything else, Mr. Saloom?
No, Your Honor. So we'll sign her name by consent, send it to the court ASAP, and yeah.
Thank you. Ma'am, good luck to you. I wish you well. Thank you very much. Have a great day.
Thank you. You too.
People
Have a good day,
against
Ron.
Jalen Thomas Mosgrove. 25F51804. All right, give me 1 second here. We have a lawyer on there for the defendant.
He's up.
Attorney Corey Westmoreland praying on behalf of Mr. Mosgrove.
All right, sir, your name?
Jalen Mosgrove.
All right, so hang on 1 second. I set this for arraignment and pretrial on February 5th. He didn't show up per law. We had to issue a show cause. He didn't show up on February 19th. I issued a warrant. And here we are. For purposes of arraignment, how is he going to proceed?
Yes, Your Honor, at this time we are prepared to waive a formal reading. My client stands mute.
Officer, your name? Officer, your name?
Officer Murray.
Has he been printed since he was taken into custody?
I would have to verify, but that would be the usual procedure. This occurred to my knowledge on night shift.
Can you do that for me, please, right now?
Yeah, were you fingerprinted? Yeah. Okay.
All right. And it stands mute, waives formal reading, correct, Mr.
That's correct, Judge.
Westmoreland? Would you like to say anything regarding bond? Why wasn't he here?
Your Honor, Mr. Mosgrove's currently residing in Lincoln Park. I'm not sure if he ever received his notice because he had moved. He is gainfully employed working at Rock Foundation. He's not currently on probation or parole. He has no other pending matters at this time that we're aware of. And after speaking with him at length, he did assure me he would be appearing at all future court dates and understands the importance of doing so.
Does he have any criminal convictions?
I don't believe any assaultive in nature. I believe just driving while license suspended.
Sir, can you tell me that? Does he have any criminal convictions to your knowledge?
If you could stand by, I can verify that as well.
That's all right. Find it.
You don't know if he's got any criminal convictions.
He's got some warrants out. You don't like to show up for court. How come?
I just moved.
No.
Warrants for what? Isn't it traffic stuff? I think it's just a ticket.
What?
I
You
think
don't
I
get
have
to
a
ignore
ticket.
courts on show causes. You got 3 warrants out. One from October of the expiration date is October of 26. That was entered back on October 10 of 19. The other one that was entered back on April 6th, 26 of 22. The other one that was entered back on April 26, 22. That doesn't bode well for you. Do you work?
Yeah.
How much do you make per week?
Depends, usually from like 600 to 1100.
Officer,
It
was he
depends on
printed?
the hours. What do you mean?
I'm asking the officer if he was printed.
Oh, I'm sorry.
So yes, sir, he was printed. I have a CCH here in
Yeah,
April
I just
6th.
looked at it. I just
Okay,
looked
I
at
don't
it.
see any convictions.
Yeah, that's bad when you don't show up, Mr. Mosgrove.
Yeah, I understand.
Judges don't like that. Here are your bond conditions. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with the victim, Sophia Aloha. No contact with prosecution witnesses. No assaultive, abusive, or intimidating behavior toward the victim. You're not to enter the property address at 28822 Walnut Creek in the city of Flat Rock. You are not to enter there. You're not to go near there. No alcohol, no marijuana, no illegal drugs, no firearms, no dangerous weapons. Officer, do you have any other information on what happened at the time of this alleged assault?
Sir, at this time, I do not.
Let me see here. It says he pushed the victim multiple times. 3,010%. 3,010%. You're going to have to post $300 to secure your release. If you do this again, Mr. Mosgrove, it will be much, much, much higher than that. Do we understand one another?
Yes.
April
Yes, sir.
16th will be your court date, and that will be at 10:45 in the morning. April 16th at 10:45 will be the court date. Do you have any questions for me, sir?
No,
They'll let you make some calls.
I don't have anyone to call.
I'm sorry?
I don't think I have anyone to call.
Well, I don't know what to tell you. They'll let you make calls if you need to. I wish. Jennifer, look on the docket, see if Flat Rock's here earlier than April 16th. Will you please?
Yes, Judge.
How much money do you have?
I mean,
please?
Judge Hessen has them, it looks like on the 9th, but
What do you have with you?
I don't have anything with me. I just had to pay all my bills.
I'm sorry. I wish you would have shown up, and I wish you didn't have warrants out for your arrest. It tells me you're a flight risk, and that's how I'm handling it. Good luck to you. Again, they'll let you make some calls. Thank you very much. Also, I hope I said no firearms, no dangerous weapons, no alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Good luck to you, sir. Thank you.
Thank you, Judge.
Thank you. Do I have Speckled Frog versus Lauren Vanderpool? Are they here on file 217T227?
Peter Eschek on behalf of the plaintiff, Your Honor.
Ms. Vanderpool, you can start your video, ma'am, and tell me your name, please.
Lauren Vanderpool.
All right. Good morning to you both.
Good morning.
This is objection to the garnishment. What is your objection to the garnishment? You didn't really specify on your form here.
Because I didn't know where to start. It has been such a time lapsed 12 years ago for me. It was an unfair allegation from the beginning that I didn't know, and I still don't know how to handle. I just don't feel I owe that money, and I never felt I owed that money. And I'm here today to try to validate that.
Ma'am, you didn't show up at the hearing, right? April 20 of 17, you can't ask me 9 years later to set aside a judgment because something was unfair about the process. I mean, I'm sorry. I don't know what to tell you, but I'm always at a loss as to why some people find it convenient or necessary or acceptable to just ignore court dates. And now, and I got to tell you, if this was improper, anything unfair about this, I would feel bad. But I'm not a mind reader. I can't read people's minds that aren't in the building or aren't on Zoom now at this point about whether the debt is fair or unfair. This has been 9 years.
Yes. Yeah, I understand. I know I've been trying to, I guess I was avoiding it. I felt very defeated and I felt like I had no way of proving that what they're trying to, I guess, accuse me of.
Yeah.
There's no
Yeah.
data or
You
documentation.
graduated high school, I can tell by talking to you, right?
Yes, sir.
You took American government. You had to, right?
Yes, Your Honor.
All right. We have branches of government here, and that makes me feel bad that you have such little faith in the process.
I was young, and the life struggles I was dealing with as just being a single mother, I don't know why. I have no excuse for why I brushed it off for so long, but the garnishment that they took this year is made a huge dent in our family right now. So it's, I guess, made me want to pursue it, but it should have been taken care of years ago. You're right. I felt like I had no leg to stand on. I've never been financially well off. I've been, low income, and I can't afford a lawyer. I still don't feel like this is fair, and I don't feel like I'm going to win here, but.
Well, wait a minute. Slow down. What part hasn't been fair so far? Like when you're kind of, I'm feeling sorry for you and I can help you. But what part do you feel is unfair? You didn't show up. They started garnishing wages. 9 years later, you start to tell me that you don't owe the debt and you didn't show up. You didn't feel like it was fair. That makes me feel horrible as a member of the judiciary. It really does. But that's okay. We don't really need to go into that. How much have you garnished, counsel?
All right, well, Judge, in response, we garnished the 2017 tax refund, the 2018 tax refund, the 2019 tax refund, 2020 tax refund, 2024 tax refund, 2025 tax refund. So this is the first time that there's ever been an objection, Judge. We've had many years of tax garnishments. And of course, being that there's been 9 years gone by, my client has instructed me to continue to garnish her taxes. And that's what I've been doing.
How much is owed on the debt at this point?
$1,534.83, Judge. We have garnished $183 in 2017.
I'll believe you. Give me the figure again. 1,500 and how much?
We believe it's $1,534.83, Judge.
All right. So, ma'am, you're shaking your head. You disagree with that?
I feel like the amount has been different. I've heard several different amounts, and
Well,
yeah,
what do you think it is?
I don't think I owe it at all. I mean, it just goes to show
Ma'am,
that
I
I've been.
cannot go back and revisit a judgment that's 9 years old.
No, I don't blame you. This is because of lost paperwork. They were stating that I was taking childcare but not working. I was waitressing under the table. My pay stubs were handwritten, and my caseworker never turned them in. So it was just something I felt like it was out of my hands. And it just goes to show that I don't have the money for this. In 9 years they've been garnishing it and it still has it covered at 1,500. Like, I don't make much money. And so it's just, this year they took a lot and I've been working really hard and I need a new vehicle. So
Okay.
it's just.
Okay. I'm gonna have to find that the objections to garnishment are invalid. Now, so they're gonna get to retain that money. Now, I can do this for you. I can have an installment payment order issued now. Would you guys still be garnishing tax returns if she stays in accordance with the payment plan?
Probably not, Judge.
So by law, they could still garnish your taxes. But he's telling me, and he's an officer of the court, he's been around as long as I have, a little longer actually. He's saying they probably, if we set up a payment plan, an installment payment order that you stick to, that they're probably not going to garnish tax returns next year. Now, I can't enforce that, but he's telling me that. And until, how much assurance can you give me, Mr. Scheck, that you're not going to garnish taxes if she stays in accordance with the payment plan?
I can make that representation, Judge.
Can you put that right on the installment payment order?
Sure.
So let's do this. So I'm going to try to help you here, Ms. Vanderpool. So I'm not your enemy. I'm going to swear you to an oath. You're going to tell me what your income is, okay? And what your living expenses, and I will figure out what I think is reasonable for you to pay. Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
Okay. Where do you work at, ma'am?
I work as a delivery driver for FedEx.
Okay. How much do you make per hour?
It's a daily pay. And right
How
now
much?
it's $150 a day.
How many days do you work per week?
Right now I'm 3 days.
So you're only making
Sometimes
450.
2.
So you're making anywhere between $300 and $450 per week.
Yes.
Do you have any children?
I have 2 boys.
How old?
And I reached 16 and 14.
Okay. And you're not married, correct?
And not married. Their father's deceased, so I do receive income for that, for their
How much?
survivor benefit. They get $1,100 each a month.
What other income do you have?
That's it.
Counsel, tell me what you'd be willing to live with.
She has a substantial income, Judge. I would ask for $100 a
Just
month.
asking you, I'm asking you to give me a figure as to what you would be able
I
to
think
live.
$100 would be reasonable, Your Honor.
A month?
Yes.
Can you pay that, Ms. Vanderpool?
I certainly will try.
Well, I don't want you to tell me you're going to try. I want to help you, but
I have a $1,500 rent every month. I have DTE bills that are astronomical. I'm already struggling day to day, and feeding 2 teenage boys is, whew.
yeah, especially when they're 16, right? One of them
yeah.
16 is eating.
I
house
am
and home.
struggling. I wouldn't be here today if I wasn't struggling. So, I mean, it's a little bit of money, but it's kind of a lot to us right now. So,
Yeah, here's what I'm going to do. Mr. Scheck, you're going to put in that order what we just talked about, that there will be no garnishment of tax returns so long as defendant stays in accordance with the payment plan. So that's what you have to do, Ms. Vanderpool. I'm going to order that you pay $30 bi-weekly, and I'm going to give you a little bit of leeway time. We're going to start that on May the 1st. So every other Friday, starting May the 1st, $30 bi-weekly. Okay?
Okay.
Stay in accordance with that plan. And counsel, you can also put on that order, this order is subject to review on motion of either party on or after November 1 of 26, on motion of either party.
of 27, Judge?
No, of 26. November 1.
Give me that date once again, Your Honor.
Yeah, this order is subject to review on motion of either party on or after November 1 of 2026.
Okay.
All right?
Yes, sir.
And that is it. And Mr. Scheck, who are you working with?
I don't know what you mean.
Millicent. Who's Millicent? What's the
Oh, Millicent is my daughter, Your Honor. She's part of
yeah,
our
that's nice. That's nice. I thought so. I didn't want to make assumptions, but I see something here in the file that tells me you're working with a relative. So that must be enjoyable. Nice to have you here. Ma'am, good luck to you. Next time you have an issue, though, you have to bring it to the court, okay?
Okay.
All right.
One last question, Judge. Should I do that on a 7-day note?
No, you can just submit it to me. You can just submit it to me. I don't need it under the 7-day rule. Just try to get it in the M file today, okay?
I will, Your Honor. Thank you. Appreciate
Thank
the
you.
court's
Good luck to you, ma'am. I wish you well.
Thank you.
Thank you,
You're
Judge.
welcome. LVNV versus Floyd Morris, 2502286. This is scheduled for 9:30, so.
Yeah,
I don't know.
Judge, I have a Midland versus Sislo. Do you have that one?
Okay,
Good morning, Your Honor.
hang on one second. I need to find that one. Is that a 9:30?
9 o'clock.
It's at 9 o'clock.
I don't think I have the 5. Do I?
30 should be it.
Your Honor?
Oh, here we go. Midland Credit versus Rebecca A. Sislo, 2004682.
Good morning, Your Honor. David Karen on behalf of plaintiff.
All right, do I have Ms. Sislo? I thought I saw her out there. Ms. Sislo, you have to start your video and state your name. There you go. Your name, ma'am. Unmute, please, and tell me your name. You have to unmute.
Rebecca Sislo.
All right, this is a pretrial. Do you guys want to go into a breakout room and talk?
We did, Your Honor. And where we're at is we have done a consent judgment with Ms. Sislo, and she states she mailed it to us signed, but we're not showing it. So we're going to get that from her signed and then get it to the court. She's made a few payments already on it. It was 2 months ago that so if that's okay with the court, not sure if you just want to.
Why don't you update it then? I mean, I hate signing orders that are ordering people to make installment payment orders 2 months earlier. That's the problem.
I get
hate when
it.
that happens. So
Yeah.
let's start over.
Yeah, I'll update it.
I'll tell you what I'm going to do. I'm going to adjourn this. I'm going to adjourn it for 2 weeks, the pretrial.
Okay.
We're going to give me a date, Jennifer, please.
That would be the 21st at 8:30.
21st at 8:30. Now, you guys can work on that. You can go back and forth, do whatever you're going to do, but make sure I'm not signing an order that orders her to make installment payments going back. So you can update it, figure out how many payments she's made, how much to credit, and then take that off. Is that fair?
Yes, very fair.
All right, that's what we'll do. April 21 at 8:30.
Thank you, Your Honor.
Thank you.
Both. Have a good
Bye.
day.
Bye.
Thank you.
Thanks. Capital One versus Zayed T. Malik. Is he in here? That's 262503893.
Judge, the 9:30s aren't quite ready. They're still speaking.
Good enough. What else do I have? Mr. Raven Osborne. What is that case? Do I have a file in there?
That's an arraignment, Your Honor.
Okay. That's all right. Take your time. A lot of filers there too. Putting it in there. 40 seconds. People against. Raven Lee Osborne III, 21F234345. Everybody's name, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Osborne. Mr. Osborne, would you please state your full name for the record?
Raven Lee Osborne III.
All right, this is a 2021 incident, February 12 of 21. He didn't show up in 21. I issued a warrant for his arrest. The charge is possession of a controlled substance. Does he stand mute, waive formal reading?
That's correct, Judge.
Where are you now? In the Wayne County Jail, sir?
Yes, Your Honor.
For what?
Picked up on a warrant for our probation violation. I was given a personal bond on it, and I have court on April 28th over it in Lincoln Park for drug court.
You're in drug court and they had a warrant for your arrest because you didn't show up? You weren't a very willing participant, huh?
I was on it. I did very well in the program. I had lost my residency, which was only down the street, and I was able to get rides back and forth, and me and my girlfriend had split up, and I had ended up.
You had a warrant for your arrest out of the circuit court arising out of a felony that you pled guilty to, operating while intoxicated, third offense. So you're actually under the jurisdiction of the circuit court, true?
Yes, sir.
It's not Lincoln Park District Court. They gave you a personal bond. That was nice of them, but you don't like to show up in court, it looks like.
No, I show up after seeing the judge. I was unaware. I thought the medicine had just gotten confiscated because I had drank a lot that night, and I was walking. I ended up walking, and I ended up having to call an ambulance because I was so cold.
Well, as of this moment, you have actually warrants were issued yesterday for you out of the Third Circuit, 2 of them. And then also out of the Flint District Court, you've had 1. And then also out of the Flint District Court, you've had 1. And also out of the Flint District Court, you've had 1. So you just don't like to show up for court, which is never a good idea.
It's hard for me to commute. I don't have a driver's license at the moment.
I know, but if I told you I would give you $10,000 to get here, you would have done it, wouldn't you?
I would be there. No, I would be there if after. I didn't know that I really had court there. I know the Flint thing is just so far, but I plan on taking care of all this stuff right now.
Well, those warrants been outstanding for a long time.
Yeah, 21 years.
Yeah, I know. Right. Thank you. I wasn't going to embarrass you. Can't do this.
I understand. Every time I've seen a judge, though, I've always appeared in court.
Well, that's not true. Why are you telling me that? That's just not true.
I didn't see the judge in Flint.
Listen, I don't want to hear it, please. Thank you. Okay. You have somebody you can call to come up with some money?
I have nobody right now.
Even our friends and family get tired of helping us if we're not doing the right things.
All I have is my mother, and she's on a tight budget.
I'm sorry.
My mom only had one brother and one mother, and they're both gone now.
I'm sorry. Is this still your home address, 175 Goodell?
No, sir. I don't know. I'm moving in with my sister on North Huron River Drive, and she's going to help me commute.
Well, hang on. What is your address?
I don't know. I can't remember. I got ran over. I have a traumatic brain injury, and I have a hard time remembering the address, but I did live there with her for about 8 months, and I'm going back there as soon as I come out of here. I'm going to stay there so I can.
Listen to me. Are you going to remember to notify us of your address? We need a residence to send the mail to.
Yes, sir. I'm going to get all that today. And if I have something in writing, I got a stash of my papers I'm keeping together so I can remember everything. But the serious issue with me going on is they had found a certain type of blood in my cancer. They're not I have to have further testing of which one it is. It's either Hodgkin's or leukemia, because my T cells and my B cells were depleted in August of last year. I had got.
Jennifer, tell Heather to log on real quick, please.
Judge, she is.
Oh,
I'm here, Judge.
I'm sorry. Okay, here's what I'm going to do. 5,010%. April 16th at 10:45 will be your court date. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, starting with April 16th at 10:45.
Yes, sir. I'm not
No
gonna be.
contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. Attend AANA 3 times per week in person. This is all obviously assuming that you're posting. And every time you go, you have to have an AA form signed, some notepad, something that will indicate that you were there, that will verify your attendance. So you'd have to have somebody else signing. Every time you come to court, you have to bring that form with you. I want you to put on the bond sheet or on the minimus defendant to see medical. So we'll send him over to the medic, have somebody look at him while he's there. And April 16th will be your court date at 10:45. I hope you can post.
We're gonna need you in there for the plea.
Okay.
Judge isn't available later and the attorney,
Can you,
prosecutor has.
Ms. Francis,
another-
can you shut your, thank you. So that's what I'll do, okay? I sincerely wish you well. We're gonna appoint him a lawyer too, Heather, for that date, okay?
Okay, Judge.
Thank you. Good luck to you, sir.
Thank you, Judge.
Citibank versus Daniel Trozen, 26000186. And I also have a counterclaim. Did Mr. Trozen, it looks like.
This doesn't make any sense to me. The judge exploded during a heated bond hearing involving a defendant already on probation for a serious criminal sexual conduct case. From the very beginning, the judge made it clear he did not trust the defendant at all, openly calling the bond decision illogical and questioning why anyone would believe the defendant could suddenly follow bond conditions after already violating probation before. The courtroom became extremely tense as the judge bluntly said, "None of this makes any sense to me," while shutting down arguments from the defense. He repeatedly pointed out that the defendant had already failed to comply with court supervision in another major case, making it nearly impossible for the court to trust him again in an even more serious situation. Then came the harshest moment of all. The judge flat out said he could not understand why the court should believe the defendant would obey any conditions this time around. The entire courtroom went silent as the judge's frustration kept building with every sentence. Do you think someone with prior probation violations should ever get bond in a case this serious?